stream and everybody in the room. We are today going to talk about contracts. And if you're watching from afar on live stream, Lisa has uploaded both of these contract forms on the site and the due diligence addendum, and they're right above the video, right, Lisa? Right above the video. So if you're watching online and you don't have the contracts in front of you, then you should print them out or download them so you'll have them to look at and follow along. Because when I do the contracts, I'm going to talk mainly about the Form 310, which is the subject to financing contract. There are other kinds of contracts out there, but we are today going to focus on this one. And we will talk briefly about the other contract, the Form 300 that you have that says residential condo on it. We'll touch on that at the end. But I can tell you that it is impossible to teach this contract thoroughly in 1 hour. I have a 4-hour course on it that gets you continuing ed credit. That does it justice for 4 hours. So I am going to hit the highlights, the parts that I know causes issues with people, and things that are fill in the blanks, what you need to do is fill in the blanks. I'm not going to read every paragraph. But I will say right now to you, if you've not read this contract, every word of it, you need to do it. You need to sit down and read it. And after we have the discussion today, maybe you will be able to summarize the different paragraphs as you're talking to people. Because you need to explain the contract. Somebody said the other day that their client said, I just want to sign. Don't tell me all that stuff. I don't want to know all that. I just want to sign. Well, that's a little scary, so I'm hoping that you all will explain the contract in detail. Starting off on Form 310, which is the subject to financing residential contract. You all in that room have that in front of you. You all got it in front of you? Mm-hmm. Obviously, the parties go first. Your buyer's name, seller's name should be the name that they would like the deed to be put in. Oh, the legal name, I should say. And not, if her name is Susan and she goes by Susie Q, don't put Susie Q on the contract. Put her legal name. And if you have the buyer, you'll say, well, I don't know who the sellers are. How are you going to find out who the sellers are? Tax records. There you go. The next little section are definitions, and I'm not going to read all those. You can read them yourself. There are two critical ones in here that you have to know what they mean. You should know all of them, but effective date and business day. The effective date is the final date upon which a party to the negotiation places the final and required signatures and or initials and date on this contract, and delivers notice to cause this contract to be binding on all parties. So that's your effective date, and this is why when we talk about changes and things of initials on contracts, it is critical that you initial every change on a contract. Not only initial, but date the initials. They definitely need to be dated and initialed. I see lots of contracts with initials but no dates. So how are you going to determine the effective date of the contract if you don't have a date by the initials? You don't know when the last one was put there if you don't have that. So be sure and date any changes when they initial them. The business day. This is very, very, very important. And most realtors, a lot of our experienced realtors do not know how to count business days as of today. They still don't know how. My newbies, most of y'all, some of y'all, I guarantee you know how because we've been through this before in class. But business day, let's just read what it says here. A 24-hour period, Monday, Tuesday, Wednesday, Thursday, and Friday, beginning at 10 a.m. and counted from 10 a.m. of the first business day following the appropriate date, whether that's your effective date or closing date or stated date. Business days shall not begin, end, or include any Saturday, Sunday, or federal holiday. Now, that being said, it says right in here that your business day starts the day following the day you ratify the contract. So if you ratify a contract today, your business days begin tomorrow morning at 10 a.m. And then Thursday morning at 10 a.m. would be one day. We have a business calculator that Lisa put the link on the Oh, you haven't done it yet. But the business calculator that you can use online, it's really timeanddate.com. And Lisa's going to put the whole link on the website so that those of you who watch it later. But when you go to this website, it will calculate business days for you. However, you have to be very careful about one thing. When you put in the date here, it says today. You're not going to put, if you're ratifying a contract today, you're not going to put today's date, are you? You're going to put tomorrow so that it calculates the business days correctly. But this is an easy way to do it, and it is timeanddate.com. And when you get to that page, under calculators, you have to go to calculators and the drop down, and you go to business date, including holidays. Business date, that's important you have that particular one. So if you want to use this for calculate business days, you can.
Including holidays or excluding?
Excluding holidays. Did I say including?
Yeah.
Excluding. Y'all need that now. Right. Okay. I guess I have an extra set of those. No, maybe not.
I have one here.
So then we go on down to the next section. Under time, it says everything related to time and date in this contract is time is of the essence. That stays right down the front page, so you don't have to put it after every other time. Buyer or seller is a South Carolina real estate licensee. So if you're buying or selling for yourself, you must check the box here to let the world know that you are buying for yourself and you're a licensed real estate agent. Purchase price. Now, that seems very simple, right? If you're selling something for $550,000, you just write the numbers 550, 000, right? But you have to go ahead and write the words also. I'm saying you have to write the words. Why do I say that? Because there could be typos in the numbers. So you have the numbers and you have the words. So that way there's no misunderstanding. So it's really important that you put the words in there. And somebody told me that, well, zip forms won't let you type the words. Well, they will if you space. Put a space and then start typing the words. Actually, the other day I was playing around with zip forms and mine let me type it immediately after the number. So
I put a dash.
So it's I don't know why it let me do it. Sometimes it doesn't let people do it. So if it doesn't, then just hit space or dash and then write the words out. And the next line, payable by transfer of good funds via finance or a combination of finance and cash or cash. You check which one. You don't check two of them or three of them. You check which ones is the situation. Most of the time, you're going to be a combination of finance and cash. Because most of the time, they're putting 10% down or 20% down or something like that. Although the last year, we've seen a ton of cash deals. But I think that's interesting. I guess it was because of the stock market. I'm not sure. The next line is very important. If your people have a property to sell, the sale of buyer's real property is or is not contingent for the purchase and term, and the purchase and terms for purchase and terms are or are not attached. Just as simple as that. If you need to sell a property, it is contingent upon that. If you don't, it is not contingent. And then if it is contingent, you will attach an addendum for the purpose of selling their house or property. Property, it goes through here explaining. I'm not going to read all of this. It goes through explaining what property is they're talking about. Then you put your address, city, zip code, lot, block. What if there's no block number in the legal description? What do you put there? NA. You should never leave a blank on a contract. Never have blanks. If there's not something to go in the blank, put NA in that spot. Then you go on down to parties agree that no personal property will transfer as part of the sale except what is below or in an attachment. This gets real tricky with financing. Most lenders today do not want you putting a boat in here or something of real value. They don't want it in there because then that affects the value of the property, of the real property. Washer, dryer, refrigerator, those are pretty typical and common, and most lenders do not have a problem with that. But if you have something else that needs to go with it, like a fancy grill or something, patio furniture or something like that, then you need to do a bill of sale and attach that to the contract. Conveyance. This next is closing will occur no later than 5 p.m. on or before whatever date you pick. Please do not put in here within 2 weeks of Mama looking at the house, or within 3 weeks of whatever happening. You're supposed to have a date in here. And somebody says, well, I have a house, they have a house to sell. I don't know when it's going to sell. How can I put a date in here? You have to estimate. You go out there, 90 days, 120 days, and put a date. It says on or before, so just pick a date and put it in there. But you need to have a date.
Typically, is that like 90 or 45 days, or it's just important to put a date?
No, you can't. I won't say you can't, but you should not put within 45 days or 90 days of effective date. The state, the law is unique, so you should have a specific date.
Well, yeah, that's what I'm talking about. Like,
Yeah.
if you wanted to pick 90 days, just put it in there. It doesn't.
Oh yeah, but don't. Yeah, just go out there. And if 90 days from now is November the 1st, then put that in there.
Okay.
You could use this calendar that she has up here too.
Not me.
Yeah. All right, then it goes on to say with an automatic extension of blank business days. You fill that in. This comes into play if it's no fault of the buyer or no fault of the seller that you don't close on time. That's the only time this comes into play. The only time.
The link is on there now.
Okay. Lisa's saying the link is on the website now for the business calendar, day calendar. If the buyer drags their feet in getting the paperwork to the loan officer, that's the buyer's fault. If the seller drags their feet and doesn't get the repairs done in time, that's the seller's fault. That's not the attorney's fault or the lender's fault. If something is the lender's fault or the attorney's fault, then this comes into play. This is not an automatic extension of the closing date. It is not. And so many people think that it is. They say, oh, I got another 5 days here. You don't if it was your problem that caused the closing. It is not an automatic extension.
And do you typically use 5 days?
5 days is good, yeah. You still need to give somebody 10 days or whatever, you just don't want to do that. And we're talking about business days here, so again, that's longer than your calendar days. Everything in this contract, with the exception of the CL 100, deals with business days. And the CL 100, we get there and talk about that, it's on calendar days.
And we would still start at 10 o'clock the next morning, start calculating that, like we did for the other.
Exactly. The question was, you start at 10 o'clock the next morning. Yes, that's the definition of business days. You start, like, if it was supposed to close today at 4 o'clock, then your 5 days for extension would begin tomorrow morning at 10, so day 1 would be Thursday, and so forth. On page 2, I see so many contracts where these lines are left blank. This is the seller agrees to convey marketable title in the name of, you're supposed to put the names of the people that how they want the property deeded. Now you put their names in there. Typically it's the same thing as the buyer's names on the front of the contract. Normally it would be the same. I want, right under that line on the top of page 2, it says, seller shall convey possession of a vacant and reasonably clean property, free of debris along with keys, codes, etc., etc. I had an agent come to me not long ago and said, oh man, I forgot to put in there that they would leave the house clean. Forgot to add that to the contract. It is in your contract already. This is why it's important for you to point out to your sellers and your buyers what the contract says. Because if you don't go over this with them, then they might not even know it's in there. A lot of agents don't know it's in there. Going down to earnest money, there's a lot of confusion about these blanks on earnest money. The total earnest money, whether it's $5,000, $1,000, personally, I recommend not ever going over $7,500 because small claims court, that's the maximum for small claims court. And if you have a dispute over earnest money, It's nice to be able to settle it in small claims court and not in the big courts. So that's why I suggested 7,500 or less. And that is in Charleston. Small claims court in Anderson or Sumter may be different amounts. I'm not sure about that. But anyway, so if the earnest money you intend to put down is $5,000, then that first line is $5,000, a total of $5,000. There's a period. And it says earnest money is paid as follows. So much accompanies this offer, and so much will be paid within so many business days. Typically, what this is going to say, you're going to have the earnest money with the contract. So it's $5,000 total. It is going to say $5,000 accompanies this offer, and NA will be paid with NA business days. Now, Angie the contract that she just wrote the other day, the people need to go back to Charlotte and transfer the funds. So she put in the contract that, I don't remember the amount, $5,000, and then will be paid as follows. NA accompanies this offer, and $5,000 will be paid within 2 business days, or 3 business days, whatever you put in there. And of course, then it's whether it's a check, cash, or other. Typically, it's going to be check. We do not take cash at AgentOwned for earnest money. For those who are brand new, don't ever take cash. It's too much liability. We don't want you to do that. We have a company policy that we don't accept cash. Then the buyer and seller authorizes that next blank line. That is who is going to hold the escrow money. It doesn't really make any difference. All real estate brokers in South Carolina have the same law to go by, as long as the broker does what they're supposed to do. So it doesn't matter who keeps it. Typically, if you're working with a buyer, you'll say AgentOwned's going to keep it. And if you're working with a seller, you like to say AgentOwned's going to keep it. So, it's no big deal either way, okay? Then the next paragraph is all bold and big type. I'm not going to read all that either, but it basically defines how the earnest money will be dispersed if there's a conflict. And you can read all that. Basically, the parties have to agree. A judge, a court of competent jurisdiction has to agree or say what's to be done. Somebody other than you or me has to say what's going to be done. Now, if they cannot agree, then we go to small claims court and let a judge decide there. But usually people will agree, go back and forth and agree how to disperse it. But that next blank that's in there, this is very confusing to people. I've seen a lot of contracts with NA in there or 0. I've seen them with as much as 500 in there. All you need to put in that blank is whatever it's going to take to file a motion with the small claims court. And in Charleston, it's $90. So we say put $100 in that spot. That covers it. And it's saying, what it's doing is giving us permission as a broker to deduct that fee if we have to take them to small claims court. If the buyer or seller won't do it, and the broker has to take them to small claims court, then we can deduct the fee out of the earnest money. That's the purpose of this spot.
Is that much money to file a suit in small claims court?
$90. Okay, going on down to your transaction cost. This spells out in great detail every little thing which would be a buyer's closing cost and a seller's closing cost. You read that on your own. The next line, buyer will pay buyer's transaction cost and seller will pay seller's transaction cost unless otherwise agreed in writing. This is a blank line. Nobody really seems to know why that blank line was put there. I talked to Byron King in Columbia, and it's just, he suggested you write on that line, see below, S-E-E, below. Or you put in A. Really doesn't matter. Because what they're, if the buyer or seller, if the buyer's asking the seller to pay some of their closing costs, they will say this in the next paragraph. And it used to be that agents had such a hard time writing this verbiage. I love the fact it's in the contract. You don't have to worry about the verbiage. It is there already. If it's a dollar amount or either 3%, 6%, depending on what the lender will allow for that particular type of loan, is what you put in there. Or it doesn't, the seller doesn't have to pay any closing costs. Just depends on what is being offered in this negotiable item. I want to call your attention to the last sentence of that paragraph. If there is no closing, The buyer is responsible for the buyer's transaction costs, and the seller is responsible for the seller's transaction costs. Buyers and sellers need to know that. Finance, this finance clause has been a thorn in my side for a long time, but it's still a thorn on this contract. This contract is either contingent or not contingent upon paying financing. And if it's financing, is it a 30-year, a 15-year, or some other type of financing? Just check the box that applies. Then it goes on down and says it amounts to a minimum percentage of the purchase price or appraised value, whichever is lower. A lot of experienced agents have trouble with this because contract used to say minimum and maximum. It says minimum now, but so if they're getting an 80% loan to value, you put 80% here. If they're putting 10% down, you put 90% here. Byron King, the attorney for South Carolina Association of Realtors in Columbia, has told me that the assumption here is 100% is the maximum. So put whatever loan to value they're doing. Then going on down to the last line, the buyer shall apply for financing within blank business days from the effective date. Typically what I see in here is 5, but a lot of times, most of the time actually, your buyers have already been pre-qualified, and maybe they've done the loan out before the contract. And if that's the case, you just put 1 or 0 if they've already done it. And then the top of the next page, page 3. This is the thing that I have heartburn with. And shall provide the seller with reasonable, satisfactory written loan approval that contains no credit income or asset conditions within blank business days from the effective date. You're just not going to get that till you go to closing. No asset conditions, no income conditions. So I don't care what you put in that spot. It doesn't make any difference. Okay? You can put 2 days, you can put 25 or 30 days, you can put whatever you want. Because it really doesn't matter. You're not going to get that kind of approval. So
what should we put?
2 days close.
the question is, what should you put?
Same days you close.
Typically 20. Most people put 20. And going on down, and hopefully the lender is going to be Prosperity Mortgage, hopefully, always. If you don't know who the lender is going to be and your buyer is insisting on talking to several people, you can put TBD, to be determined. Of course, you've got to check the type of loan it is, whether it's VA, FHA, conventional, or whatever. If it's FHA or VA, you have to attach an addendum to the contract. And you have spots to do that. Now, the next section of repair procedure. Typically, if you're working with a buyer, I do not recommend this repair procedure of the contract. It is either repair procedure or due diligence. It's either or. It's amazing how many contracts I see that have the repair procedure, but then in the addendum, they'll add an addendum that says the home inspection is the sole satisfaction, sole discretion of the buyer. That's due diligence. So why not just use due diligence? There are conflicting stories there. If you've got the repair procedure, but yet they're saying it's got to be to the sole satisfaction of the buyer, you should use due diligence if you have a buyer. There's very rare cases where I don't think that's the best thing to do. When you use due diligence, you have to be extremely careful that you've calculated your business days and know when that due diligence is up. It's extremely important that you keep up with that. But if you're going to use the repair procedure, the reason I like the other, if you have the buyer, say that you've got to have a contract on a house that's an older house and CL 100 comes back and it's got a huge amount of work to be done and the seller says, well, I'll fix it. Or maybe on your inspection, a huge amount of work comes back. Maybe the beams under the house, the joists under the house are bad and all that's got to be replaced. The seller says, I'll do it, I'm going to fix it. Your buyer says, I don't want that house. I'm scared of it. I'm afraid. Well, if you've got a repair procedure, you're stuck. If that seller fixes it, the buyer is said in this contract, they will go to closing. So that's why I like due diligence. Because your buyer can get out of the contract for any reason whatsoever. They can get out if they don't like my hair color. They can get out for any reason. But if you go repair procedure, you gotta be careful about the dates that are in here. That you put a date for the inspection, and then if there are repairs after the inspection is done, then the buyer has 2 business days to let the seller know about the repairs. Then after the seller gets the repair addendum, they have blank business days, whatever you put in here, to reply to the buyer's repair request. If there are a lot of repairs, typically you need to put maybe at least 5 business days if there are a lot of repairs, because the seller's got to get estimates to see if they can fix the things. So it depends on how many repairs you're putting on the repair addendum, is how many days you put in that spot. I wanted to bring your attention that it says right above that spot where you put in the business days for the seller to respond, right above that you'll see it says, the seller shall be delivered notice in writing of the specific defects or deficiencies no later than 2 business days after repair procedure. If the buyer fails to notify the seller within this time frame, the buyer shall have waived any and all rights for the inspection. So if you're using this, you've got a date in there, you better be paying attention to it, if you've got the buyers. Then in section B, we said whatever business days you're going to put in that spot for the seller to respond to the repair request. Then go on down, it says, if the seller agrees to make the repairs, the parties agree to proceed under this contract. It says it right there. If the seller's going to make the repairs, the buyer needs to close. And we go on down to the, right above section 9, the paragraph above is in all caps. It says, if a due diligence addendum is signed, dated, and timed by all parties, the parties agree that the language in the due diligence addendum shall replace the repair procedure language. It's one or the other. It's not both. If you use the repair procedure, you've got how many dates you've got to keep up with. You've got the inspection date, you've got the 2 days after the inspection, then you've got the days that the seller has to do. It's 4 dates in there that you have to keep up with. Whereas if you do due diligence, you've got 1 date to keep up with. Number 9, the inspection rights. We're not going to go through that, but I do want to call your attention to the fact that this does cover the walkthrough inspections, and hopefully none of you ever go to a closing without doing a walkthrough inspection with your buyers first. And if you have the seller, the listing, you want to make sure that buyers have done the walkthrough. You make sure that, because it saves problems from later. There's going to be a problem, let's find out before closing. And then under that, it's about the sellers will leave the utilities on or not. Moving to page 4.
So those you would recommend is NA and number 8 and the due diligence.
Number 8, I recommend NA in those spots and just use the due diligence.
Okay.
If you have a buyer. Now, if you've got the seller, you would encourage the repair procedure from the other person, right? So it's kind of which side are you on? Number 10, the appraised value. Hopefully, prayerfully, you always have it contingent upon the appraisal. If it's a cash deal, you still should have it contingent upon the appraisal. I know that you all think you know how to tell people what houses were, and I'm sure you do, but please don't do that. Don't be caught giving somebody an appraisal. You're not an appraiser. So it's suggested they get an appraisal. They need to have that done. Wood infestation report. This is the only part of the contract that actually is calendar days. It's not business days. It is calendar days. But you check whether you have the buyer or the seller get the report and who's going to pay for it. If you have the buyer, I've always said I think it's good to have the buyer get it and the buyer pay for it. And it's good for the seller pay for it if they want to. That'd be great. But have the buyer select the company. Some people disagree with me about that and say if there's a termite bond on the property, you should just let the seller do it and let the person who has a termite bond give the letter. So that's kind of you fill that up and let your buyer make that decision, what they want to do. But the calendar days is important because typically most of the time you put in here 10 or 15 days, probably 10. You don't want to wait too long to get that CL 100 letter. It's only good for 30 days, period. So once you get it, if you don't close on time, then you have to get another letter. So you just, typically 10 days in here. Get it no less than 10 days before closing. But remember, it's calendar days.
So I have a question. So my closing date is October 29th, and so if I were to put, I think I put 10 days in there, they would have to get now 2 letters now. One before 10 days and then one.
No, 10 days before the closing, but they don't have to get a letter now.
Oh, okay.
Now, her question is a good question. She said if she puts 10 days in there, her closing is not till November. Say November, it's a long time. Then you wait till 10 days before the closing in November to get the CL 100 letter. Because otherwise you'll be getting another one. Now, if you have reasons to think that there's a problem with the CL 100, you want to get it done during the due diligence period, then you might need to have 2 letters. Because due diligence, again, is for everything that your buyer is concerned about. However, the contract itself, finance, the appraisal, and the CL 100 are outside of due diligence. That's by definition. Finance, CL 100, and the appraisal are outside of the due diligence. However, if you've got a buyer and you have some concern maybe about the CL 100, then I would suggest you get a CL 100 during the due diligence so that you can get out for any reason. Because if the seller agrees to make the CL 100 repairs that might be needed, your buyer is saying they'll close. They'll go forward. So you need to, it says if the seller does not make the repairs and treatment, then the buyer has options. They can accept the property the way it is, they can negotiate with the seller, or they can terminate the contract and get the money back. But if the seller agrees to fix it, the buyers are stuck. Now, this is outside of due diligence, so if you don't do a CL 100 during due diligence, they could be stuck, if that's a concern. Number 12, survey, title, and insurance. It's just saying that we recommend everybody get title insurance. Owner's title insurance, it's got the word in here, including owner's title for your insurance. We always recommend people get the property surveyed. I want you to go on record recommending that they get it surveyed, even though an attorney might tell them, oh, you don't need to pay that money because we've got a plaque from former sellers. I disagree with that theory. You go on record as recommending that they get it. Now, if they don't get it, that's fine, but you recommended it. As a matter of fact, we have a form that all of you have to have signed in order to get paid that says we recommend these things. So, but I like to make sure that you know that you do point out that they do need to get the survey. 13 is pretty simple, speaks its own language, survival. Y'all know what survival means? If there's a condition that survives the contract, such as, we had one not long ago where the seller was to replace 6 windows in the house. They ordered the windows that did not come in time for closing. So that was a part of the contract. So that, they agreed that the seller would do that after closing. So that part of the contract survived the rest of it. It's unusual that you have that, but sometimes you might. Number 14, the home warranty. I see a lot of contracts, and I look at every contract that comes in this office since it's done the new contract. And it's really interesting what I see. And y'all can learn from those experiences. But I see a lot of the contracts that come in do not have this properly filled out. They agree that a home warranty is ordered by, whether you're going to have the buyer do it or the seller. One or the other, buyer or seller. Typically, you want the buyer to order it if you're representing the buyer. With at least 12 months of coverage after closing date. It will or will not be provided by closing, and blank dollars will be paid by buyer or seller. Those in there. Typically, you're going to have paid by the seller, hopefully, if you represent the buyer. Home warranties are very, very important for you to protect you after closing because if things go wrong, then you've got the warranty to fall back on. On this, typically, if you're representing the buyer, you would say the home warranty is ordered by the buyer for each 12 months. It will be provided by closing, and say $450, $500, whatever the amount is for the particular plan that you want, will be provided by the seller to the home warranty company, buyer to pay any deficit, and surplus reverts to payer. Proposed home warranty company and type of home warranty. That's left blank all the time. Proposed home warranty, hopefully if the house is in good condition, it'll be Global Home USA. And you also should put the type of, whether it's a premium, elite, what plan it is, should go in there as well.
And you said put buyer or seller, you put the name or
No,
you just put
the
seller?
word, buyer or seller. That's a good question. The question was, do you put the people's name or you just put the words? You put the words. And of course, the bottom of all these pages have places for the buyers and sellers to initial, and you will want that done. On page 5, number 16, this is the South Carolina Residential Property Condition Disclosure Statement. Most of the time, you're going to check the first box. That is supposed to be on MLS, and so you can download it and have it for the buyer that you will deliver to them prior to signing this contract. 17, lead-based paint. That's pretty self-explanatory. You have to give them a disclosure booklet about lead-based paint if the house was built prior to what? 78. And you give them the booklet as well as they have to sign that form. The other day, Angie came in and we keep talking about the contract she just did, but the seller had the lead-based paint addendum out up on the MLS, but the seller hadn't done anything with it. I mean, that seller hadn't marked anything. So we were saying that a buyer couldn't mark it and do their part until the seller had done their part. So you have to be sure it's all done correctly. Megan's Law number 18. I'm going to tell you about this is you should tell your buyers that if they have concern about sex offenders, they should contact the sheriff's department. Don't you go on record as telling somebody that there's a sex offender down the street. That is not a good thing to do. Even if you think you know there is one down the street. You don't really know for sure. You don't know what kind of sex offender it is, if it is a sex offender. So don't get into that. Our company attorney has said you all do not do that. That's asking for trouble. The trust account, this agent-owned, if the earnest money is being held by agent-owned does not pay interest on the trust account. So your check may not. It doesn't matter which one you check, because the interest is not being paid anyway. So that's not a biggie. But typically you'd say may not. Number 20 is the South Carolina on non-resident gain, the tax, and you need to be able to explain to your buyers or your sellers what that means. So hopefully y'all know what that means. Everybody know? Yeah? All right, good. Number 21, this says that this is entire agreement, this contract. There's nothing else that has not been written here that would be binding on the parties. Good adjustments, number 22 talks about how the things will be prorated. And 23 talks about default, and you should definitely go over all of this, as I said, with your buyers and sellers. Number 24 is a mediation clause, which the buyers and sellers are signing, saying that if they have a conflict, they will go to mediation before they sue. Now, the escrow funds are excluded from that. Escrow funds are different. So you go to small claims court, escrow, but anything else, they're agreeing to mediate. And 25 is self-explanatory. 26, 27, 28. We get to 28. This is saying if there are any additional documents, addendum, or anything like that that will be attached to the contract, you need to list it here. Put it in this spot. And if you represent the buyer and you're doing as I suggested, you write in here, due diligence addendum. Those words, write the words, due diligence addendum. Now, if you have other addendum that go with it, addenda, I guess it's a plural, then you would list those here as well. Addendum A, addendum B, whatever they are. List them all here.
So if you had like the lead base, would you put lead based on here or not?
No, typically not. And we're going on to notice of delivery, just defines what that is, and then the parties, number 30, self-explanatory. 31, the expiration of the offer. This is when you are negotiating and you put your time frame that this other party has to respond. If you have a buyer and they're from out of town, and the seller, the house, the listing is very popular, you're going to put a very short time frame in this. Unless you know the seller's overseas or something, and they can't do it. But typically, if you're writing a contract this morning, you're going to put 5 o'clock this afternoon as your expiration. You do not want them to shop your contract, the other agent. And that's what will happen. I'm sorry?
And the other agent's gonna get mad.
Yeah.
Other agent gets mad when you put that time frame.
Yeah, I put 5 and he was mad, but.
You know, that's their problem, right? That's their problem. You gotta work for your buyer if you're representing the buyer. Then the next thing that a lot of people forget or don't realize is here, in witness whereof, see that, and then go down to that, and if signee is not a party, appropriate legal documents, power of attorney, corporate authorization, are attached or either to be delivered. When are you going to need to use this? If somebody is signing for an estate, you need to know that they have the paperwork authorizing them to sign for it. The seller needs to know that. If you representing the buyer and that's the case. Maybe somebody has an LLC or a corporation that they're putting the contract in. Then you need to have paperwork saying that person has authorized to sign. So that's what that's for. And then of course you got your signatures. And this brings up the point of witness. And if you do not physically see that person writing their name, do not put your name as a witness. And I've had people do that, and it's cost them money. Do not do that if you don't see them actually doing it. If your clients are in Charlotte or New Jersey or somewhere, maybe using DocuSign. If you're using DocuSign, for goodness sakes, don't initial their signature. If it's DocuSign and they're out of state. There'd be no reason, if you're using DocuSign, you would never be there when they sign it, right? I can't imagine a time where you would be. So if it's DocuSign, then you're not going to put a witness down there. And witnesses are important, but they're not critical. So if you did not actually see them do it, don't you put yourself as a witness. And page 8, people think it's not important. I think it's very important. The top, of course, is your earnest money, and I'll stress again here that if you do not have the earnest money check in hand, do not sign this. That could cost you money. It could cost you the amount of the earnest money if you say you have it. An agent came to me this morning and said, I've got a copy of the check, but I don't actually have the check in hand. Can I sign this? I said, only if you want to be responsible for the amount of money. I would not sign it until you get the check in hand. And then a lot of people have questions with the next one. Escrow agent name, broker in charge, or other. They're looking there for AgentOwned Realty if we're holding it. We're holding earnest money. And then the next line are your brokerage, law firm, or other. We're brokerage. And then the next 2 lines are for your contact information. If AgentOwned is holding the money, you put your name and contact information. And then please remember that if you're going down the buyer and the seller side, you need to check whether you're a buyer's agent, or seller's sub-agent, or a buyer designated agent, or deal agent. You need to check which one of those you are. You do not include your buyer agreement with the contract, but you let people know that you're a buyer's agent. I've had some people include the buyer agreement with the contract. That's really not anybody's business. You know, it's not the listing agent's business what you've done with your buyer as far as the contract goes. Now, due diligence. Let's look at that real quickly. The due diligence addendum is really self-explanatory. It is so simple. The only thing really to worry about here is how many business days you're going to put in there. And right now, I haven't found that in home inspections are taking that long. Any of y'all find that they're taking a long time? Home inspectors seem to be pretty caught up. So, 10 business days is plenty long enough most all the time. Angie smiled. Angie put 20 business days and she got by with it. The other agent let it go. That's a long time. That's a month. You look at business days, that's a long time. So typically, this was Angie's first contract, and she did great. She did a great job. But,
If they didn't live here, so.
and they didn't live here, right?
Up here at St. Paul.
The other thing about this due diligence addendum is the blank down there where you put a termination fee. If you're representing the buyer, you want to put 0 down there. And the other day I was on the zip forms playing with it, like I said, and it would not take a 0 for me. So I wrote the word 0, Z-E-R-O. It took that. So somebody said it wouldn't take 0 for me, so I put $1. Well, the problem with the dollar is we did that. I had an agent that did that one time, and it sure enough, it terminated. Then she had to get that $1 to the person. You know, to be binding with and following the contract. So put 0 if you're representing the buyer. Now, if you're representing the seller, in this case, I'll pick on Angie again. This contract she wrote for a 60-day closing, that's a long time for closing. And if I were the listing agent, I probably would not have taken that because it's just too long. So you have to negotiate all of these kind of things.
That's why when you're on the side of hogs, like, you know, make a decision quick.
Make a decision quick.
Just turn the knife a little deeper.
But the 0, the termination fee, if you're representing the seller, then you will put something in there. Like in this case with Angie's 60-day closing, if I had been that listing agent, or you had been, I would have recommended to you that you put $1,000 or something in there. They're keeping their house off the market. They're entitled to money for keeping their house off the market. They didn't do that. But if you were in the opposite shoes, that's what you should do. You should tell the seller, okay, we'll go with this, but we're going to get some termination money, especially a 20-day due diligence. So, all that being said, I want you now to pick up the Form 300, which is the residential condo subject financing contract. I'm going to point out the things in this contract that are different from the one we just went over. This contract is almost exactly, well, it's not, it's very, very similar to the one we just went over. Even though it says condo, there used to be one that was just for condos, and that has been changed. And a lot of people are using this form for their subject to financing for residential property, and that's fine. It's not a problem with it, as long as you understand the differences between the two contracts. On the front page, for one thing, on page 1, under property, this is what makes it a condo contract. If you read down in there, like the third line down, it says any personal property conveyed in same operable, well, that's not what I'm talking about, but same operable condition. That's different because on the subject financing contract we just looked at, it said working order. It's pretty, I guess it means the same thing. But go on down, subject to normal wear and tear. Buyer acknowledges opportunity to inquire about owners association issues, common area issues, condominium master deed issues, assigned parking storage areas, memberships, and lease issues prior to signing the contract. That sentence is not in the other contract we just went over. It's just not there. So that has to do with condos. That's the only thing in this contract that has to deal specifically with condo. That's it. Everything else in here is regular residential. Yes.
I'll listen to a little bit of that. Wouldn't you kind of want to know those things about a regular house if there were any kind of like parking issues or?
Well, not yet, but this is condo association.
Gotcha.
Yeah.
Okay.
Okay, page 2. Another huge difference in the two contracts. I mean, this is huge. And this is why some agents like to use it. Going in the earnest money section and the big bold paragraphs, go down like the third sentence down. It says, unless otherwise agreed upon in writing, the parties agree that the escrow agent shall disperse the earnest money to the buyer unless the seller's attorney has filed a lawsuit to determine distribution of the earnest money within 30 business days of the closing date. That's huge. It's saying that it's authorizing the broker to give the money back to the buyer unless the seller has filed a suit within 30 days after the closing. After the closing date, it was in the contract, not closing. The closing date. if there's a problem that's come up and there's a fight about the earnest money, and if it was supposed to close today, which is August the 26th, within the next 30 days of that date, the seller has to file suit, or the buyer gets the money back.
And that's 6 weeks, not a month.
Yep, 30 business days, right. That's a big difference there. And then going on around finance section, there's differences here. This one has the minimum and maximum percent of purchase price. And a lot of agents like having the minimum and maximum. So if you like that, but I'm telling you, if you use this contract, guys, please make sure you explain this earnest money to your buyers and sellers. Make sure they understand that. On the top of page 3 is another difference in this contract, the two contracts. This makes me feel better about the finance clause. This says, the buyer shall apply for finance within blank business days and shall deliver notice to the seller of reasonable pre-final loan approval. Reasonable. That contains no unreasonable credit, income, or asset conditions. Well, that's a little better than the other one. The verbiage is a little better. And it also says here, no repairs are required prior to the notice. So repairs are not, you can't require a seller to make repairs until they've been given notice that the loan is approved. That's what it's saying. And I think that might be all the changes. Pretty sure it is.
So you're saying that, this escrow money, that we should use this contract to protect our buyers because of the escrow?
You can use this contract with your buyers, period. I mean, it really is the same thing. For residential, you can use it for residential or condos. The thing is, if you do use it, you make sure your buyers and sellers understand that escrow thing that's there. That's important. That's big. That's really big. And the reason they do it, Byron King told me they're experimenting with this. They did this in the contract to experiment to see how it works and how agents like it. I don't really know how I feel about it. I'm just afraid that my agents will not explain it to the buyers and sellers. And then that would be a problem. What kind of questions might y'all have? We've got about 5 minutes. We can have questions. Anybody got any? Easy peasy, right?